Oh my gosh.
You mind if I put it there?
Yep.
Okay. So I get those. yeah. All
I
right.
can see it moving this way.
Hopefully there's an attendance sheet going around. Anybody see that? Someone has an attendance sheet, right? Okay, good. All right. If you're here, be sure to sign in. But welcome back, everybody. Where we left off was, remember I jumped from 6 to 10. I told that great 7, 8, 9 joke, and in walks Nick Shanine with the ba-dum-bum. Perfect timing, right? That's what comedy's all about, right? That's what I'm all about. No, wish it was. Perfect timing. But anyway, so we jumped from 6 to 10. 10 over here on our list of when does Florida's Supreme, I always put that in air quotes, Supreme Court have jurisdiction. If it's on the list, they have jurisdiction. If it's not on the list, they don't have jurisdiction. There's no implied jurisdiction. There's no catch-all at the end of the list. This is the end of the list here, and you can see it's not a catch-all. This allows Florida Supreme Court to render an advisory opinion. When and to whom? Can render an advisory opinion only to Florida's Attorney General. Florida's Attorney General. So if you ever see on an exam or a bar exam, can there be a Florida Supreme Court advisory opinion? If you're ever in practice and you're wondering yourself, can I get a Florida Supreme Court advisory opinion? It's easy to figure out whether you're entitled to that advisory opinion. First, go to Google, right? Google the name of Florida's Attorney General. Under Florida's Constitution, that's an elected post, right? You'll see her name there. Then reach for your wallet, right? Take out your photo ID. It too will have a name on it. Now compare the name on your photo ID to the name of Florida's Attorney General. Do they match? No. If so, you're entitled to an advisory opinion from the Florida Supreme Court. If not, then you lack standing. You can't bring that advisory opinion. All right? So don't be fooled, either in practice or an exam question. 7 and 8 and 9, which bring us to our discussion of extraordinary writs, which means today we get to play everyone's favorite game show. Name that writ, which is why I'm dressed like a game show host. Yeah, all right. So 7, 8, 9. This is when Florida Supreme Court has jurisdiction in certain circumstances for certain extraordinary writs. We've already talked about in great lengths at prior lectures the writ of habeas corpus. So we won't be covering habeas corpus today other than to note that that is a type of writ that Florida Supreme Court can entertain. Also, you see, Florida Supreme Court can entertain a writ of prohibition and all writs necessary to the complete exercise of Florida Supreme Court jurisdiction. And that particular phrase, number 7, does not contain a restriction as to whom the writ from Florida Supreme Court can be entered against. Compare that to number 8. Here, Florida Supreme Court can issue writs of mandamus and quo warranto, but not to anyone or everyone. Specifically, the subject of that writ, the person to whom the writ is directed, has to be a state officer or a state agency. So that would exclude local agencies, would exclude local officers, indeed would exclude anyone who's neither a state officer nor a state agency. So again, Florida's Supreme Court may not be so supreme because unlike other Florida courts, it lacks the power of writ of mandamus or quo warranto, except as to state officers or state agencies. What are these writs? Nick Shanine talked about them and he described them well. I loved his analogy of riding on a unicorn. Did you like that? I like the way he described how an extraordinary writ is just that. It is an original action that is filed in a court which typically has appellate jurisdiction. It is akin to an appeal, but it's not an appeal. When there's been an order entered by a court or an action taken by either an elected official or other government official, and there isn't an available avenue for an appeal, in that instance, you may want to explore whether an extraordinary writ is available. To say the same thing in a slightly different way, If you can file a notice of appeal, then an extraordinary writ is not the right avenue. An extraordinary writ is a lawsuit started in the first instance in that court of primarily appellate jurisdiction. Prior to an extraordinary writ, you don't have a trial. You don't have either a bench trial or a jury trial. Indeed, you're not before a magistrate or a judge or any fact finder before the filing of the extraordinary writ. So the extraordinary writ looks a lot like an appeal because you don't need an appealable order in order to file the extraordinary writ. So if you've been aggrieved by a court order or aggrieved by government action or even aggrieved by a lack of a court order or a lack of government action, you might be able to do something about that by filing one of these extraordinary writs. Let's look at them in turn. Let's look first at a petition for writ of mandamus. This is seeking a remedy for the fact that the government is inactive. A petition for writ of mandamus seeks to remedy a government's failure to do something it was supposed to do. So you've got a government actor, could be a court, could be an elected official, could be an agency, some actor of the government was supposed to take action and is not. Mandamus. So what you've got there, you've got to seek to try to enforce, and the word clear is used twice here for emphasis, because this is not an action where you establish a legal right. This is not an action where you debate whether there is a legal duty. There must be a right to action. And there must be a duty for that particular government actor to act. If you can meet those elements, then you might succeed on a writ of mandamus. Note as I talk about the writ of mandamus and the rest of these words, the rest of these writs, I keep using wiggle words such as you might succeed. The reason I have to speak that way is that the remedy for every extraordinary writ is at the discretion of the court. What I mean by that is, if you identify all the elements of that action for the extraordinary writ and you satisfy all those elements, you meet your burden of proof, will deny you the relief you seek. You can prove entitlement to the extraordinary writ, and the we will discuss today are discretionary. This is where you are seeking a remedy because you think a court is doing something of higher rank that has jurisdiction over the court, that prohibiting the action of the lower court. Now, in certain circumstances, a lower court might do something wrong. They might even enter an order that's not a final order, and they may proceed onward. You might bite your tongue, so to speak, and seek your remedy at the end of that case by filing a notice of appeal once the judgment is entered. Let's call that a plenary appeal, because the entry of that final judgment would then, subject to review, if you seek it, all the interlocutory or prior orders that were non-final orders. But when will that judgment come? What if you are aggrieved early in the case? You might not get review over that interlocutory order until many weeks, many years later, when the final judgment is entered. What if the harm is too great to your client to wait that long? That's when you might explore the possibility of a writ of prohibition. A writ of prohibition is a means by which to seek a greater court's order, preventing the lesser tribunal from doing something it should be forbidden to do. That's one use of a writ of prohibition. Remember, Nick Shaneen talked about the writ of quo warranto. I don't speak Latin. Anyone speak Latin?